Paul, for the kind invitation. Actually, I don't think the suggestion of talking about dishonesty came from me. I think my suggestion was actually medicinal cannabis and nitrous oxide. And then somebody said, well, maybe that's not a good idea, talk about dishonesty instead. I'm going to be, I think, quite radical, because it seems to me the time has come for the Law Commission to review the law in relation to dishonesty. Should we take it out of the lexicon of the criminal law? Or if we're going to keep the notion of dishonesty, should the Law Commission consider whether the test that ought to be applied should be primarily subjective or objective, or a combination of the two? Because as you appreciate, the Supreme Court in the case of Ivy Casinos has decided, and we'll come on to the details in a moment, have decided that the test for dishonesty is really objective, applying the standards of the ordinary person. And that dishonesty, as to what that means, well, it's a bit like your proverbial elephant. You'll know it when you see it. Well, how realistic is that? So the first question I'm going to pose really is this. It's the obvious one. What do we actually mean by dishonesty anyway? Well, just to illustrate the point, there is a game called the shell game. You may be aware of it. 3 shells. By the way, this game is about 2,000 years old, maybe 5,000 years old. A game involving 3 shells and a stone appears to be placed under one of the shells, and then the spectators are asked to say, well, where is the stone now, under which shell? And everybody calls out, it's the middle shell. Lift up the middle shelf, it's not there. It's the second shell. Lift up the second shell, it's not there. It's under the third. And then the routine is repeated. Where's the shell, where's the pebble now? Ah, it's under the middle shell. No, it's not. Second one. No, it's not. Third one. No, it's not. And then mysteriously the pebble appears somewhere else. I call it a game or a routine because in fact it is a conjuring trick, a very, very old one. And if you were to see that performed, and you know there's a conjuring performance that you're witnessing, although you've been deceived quite deliberately by the conjurer, you wouldn't say that his or her conduct was dishonest, would you? But let's say the same routine is played out on Westminster Bridge, as it often is, for stakes of £20 a time. It's a trick. Money is being received by the performer. Now, if you're aware that sleight of hand is involved, you still might not regard that as being dishonest conduct on the part of the performer. But if you're not aware that trickery is involved, would you regard that conduct as cheating and therefore dishonest or not? And so that very simple example illustrates a number of points that we need to consider. Firstly, dishonesty clearly is not a simple concept. Secondly, a precise definition of what it is elusive, if not impossible to state. And we're not going to be helped by looking at dictionary definitions because the definition is so broadly drawn. Thirdly, dishonesty clearly does not consist of a fixed and closed set of community norms. Fourthly, whether something is dishonest or not depends clearly on the context in which things are done. Fifthly, the expression dishonest can be descriptive of conduct or applied subjectively in terms of what was in the performer's or the defendant's mind. And finally, an everyday understanding of what dishonesty is may not be apt when what is at stake is criminal liability. So we may have to temper our definition of dishonesty in order to either inculpate or exculpate a person by virtue of the application of that definition. There are several important points that need to be kept in mind when we're talking about the notion of dishonesty. First of all, and it's important to bear these points in mind when you're looking at the range of cases, dishonesty, you may think, is a term of legal art that features in every jurisdiction that you can think of. Not so. Yes, in Australia, New Zealand, Canada, but not, as far as I can tell, in the United States of America, and not even in Scotland, that tends to talk about fraudulent conduct. Secondly, the expression dishonesty appears in legal language, really for the first time, in the context of the Theft Act 1968. And I mention that for a particular reason when we come on to look at the judgment of the UK Supreme Court in Ivey. And thirdly, dishonesty is surely a very poor substitute for the expression fraudulent, for example, which can be defined in terms of conduct elements and mental elements. Well, when considering dishonesty, what is it that we're actually looking for? So going back perhaps to the root in terms of how we define what dishonesty really is, and I'd be interested to know what your definition is. In Feely, the Court of Appeal put it this way. They said that dishonesty is really a moral inquiry looking to moral obloquy, not an expression that tends to be used, in my experience, at the Snaresbrook Crown Court. And so in Feely, they said, for example, in our judgment, a taking to which no moral obloquy can reasonably attach is not within the concept of stealing, either at common law or under the Theft Act. And later, we find it impossible to accept that a conviction for stealing, whether it be called larceny or theft, can reveal no moral obloquy. Well, what does that mean? What would an ordinary person, how would that person judge the conduct of Robin Hood, for example? They may say, well, there's no moral obloquy in connection with the activities of Dick Turpin or Robin Hood. And then we come on to the very difficult question of how is dishonesty to be assessed? Do we look to what the defendant believed, his or her assessment, or whether their conduct was dishonest or not, or should it be objectively determined? Now, academics would say, not lawyers, practicing lawyers, but academics would say to this, well, dishonesty can have a positive and negative role. And in relation to theft, for example, if I go into a shop and I pick up a tin of beans and drop it into the basket, I've appropriated property belonging to another. I do intend to permanently deprive. Therefore, I've done everything that is required to commit the offence of theft, except for the element of dishonesty. And if dishonesty, therefore, does all the work, and if it has to be determined objectively, what mens rea element is left, so far as I'm concerned, as the accused? So although it's tempting to say, indeed was my view initially, that maybe this distinction between positive and negative roles was somewhat academic and of no real practical importance, I'd rather change my mind on that. So in terms of the test, we have Gauche in 1982, and you've got the test set out on the handout. The jury must first of all decide whether, according to the ordinary standards of reasonable and honest people, what was done was dishonest, step number one. And if it was, then the jury must consider whether the defendant himself must have realised that what he was doing was, by those standards, dishonest. The interesting thing about the case of Gauche, when you look at the judgment very carefully, 95% of the judgment is reasoning along the lines of dishonesty is subjective. It's what is in the actor's mind that counts. And then right at the end, there's a 180-degree turn when the Court of Appeal, probably worried about the Robin Hood scenario, say, well, actually, the test is essentially objective, but with this twist that the defendant himself must believe that ordinary reasonable people would think the conduct to be dishonest. Well, it may be an unusual way of approaching an issue. On the other hand, an approach akin to Gauche has been applied in breach of trust cases and, until recently, in disciplinary proceedings as well. So that was where the law stood for a good many years, until 2017, when the UK Supreme Court took it upon themselves, as a matter of oversight, to alter the test, which you've got on the handout. And cutting a long story short, they deleted the second limb of the gauche test. So now the test to be applied is entirely objective. Was it necessary, I'm asking you, for the Supreme Court to have taken that step? Well, they gave 6 reasons that I want to consider with you as to why gauche, in their opinion, the second limb, created serious problems. The first was, they said the second limb had the unintended effect that the more warped the defendant's standards of honesty are, the less likely that it will be that he will be convicted of dishonest behaviour. And the concern that the Court of Appeal, and indeed the Supreme Court had, was that of bankers, those engaged in the financial services, who perhaps took the view, well, everybody is altering rates and indulging in certain practices. We don't think there's anything dishonest in what we're doing, when an ordinary bystander would say, we object to these practices, we think that conduct is dishonest. And so in the case of Hayes, you've got a graphic example of that, where the then Lord Chief Justice, in quite strong language, said the history of the markets has shown that from time to time markets adopt patterns of behaviour which are dishonest by the standards of honest and reasonable people. In such cases, the market has simply abandoned ordinary standards of honesty. Is it a legitimate complaint, or viewed objectively, was the Court of Appeal really being somewhat unrealistic in terms of what happens in practice? There's a very interesting article by James Wilson, you can have the details from me later, which is, I'm afraid, is only available online, but it's called Giving Up the Gauche Test. And I said it's available on the internet, 28th of February 2018. And the point that he makes is this: why worry about that particular reason at all? Because the second limb of gauche is actually self-limiting. I mean, the more warped the defendant's sense of perspective is about what is dishonest and not dishonest, the less credible that person is going to be anyway. No reasonable jury is going to believe him or her. And secondly, my point, not his, for the last 15 years at least, the legal profession has been told we should be more trusting of juries and fact-finders to reach the right result. The second reason the Supreme Court gave was that the second limb was based on the premise that it's necessary in order to give proper effect to the principle that dishonesty must depend on the actual state of mind of the defendant, whereas the rule is not necessary to preserve this principle. Yeah, but if that's true, you would make the test subjective, not objective. And in that regard, Matthew Dyson and Paul Jarvis have written a good article in relation to, for example, the definition of the Fraud Act offences. And statements made in Parliament by, for example, the then Attorney General Lord Goldsmith, that indicate that Parliament clearly relied on the framing of the Fraud Act offences to incorporate effectively the gauche test, saying it's an essential test for criminal liability for fraud. And so, given that legislation has been drafted with the gauche test in mind, where does Ivy Casinos now leave us in respect of the ambit of those offences, for example? The third reason given by the Supreme Court was that the second limb sets a test which jurors and others often find puzzling and difficult to apply. Well, that begs the question, is the test now under Ivy any less puzzling or any less difficult? And the decision in Ivy has now been incorporated in what I still call the bench book, or the Crown Court Compendium, and a couple of specimen directions which have to be tailored to suit the individual case are set out. So one hypothetical which is stated in the compendium is that of a person who walks out of a shop with a radio, intending not to pay for it, intending to keep it, saying, well, I'm penniless, I'm living on the streets, my life is miserable, and I need some source of entertainment. I didn't think what I did was dishonest, and I didn't think anybody else would either. And so the direction which has in part the case of Wheatley in mind says that you have to have in mind when you ask yourselves whether in the light of any understanding of the situation the defendant had, you are sure that his behaviour was dishonest by the standards of ordinary, decent people. Now, true, in Wheatley, the word decent appeared. Why? Because to talk about decency is to add yet another value judgment on top of notions of honesty and dishonesty. In the second example, which I want to consider in a little bit more detail, the direction is tailored in regard to the case of Hayes that I mentioned. And the very relevant parts read, you will consider the evidence about the culture and ethos of the market together with all other evidence, including that from the defendant himself or herself, which may have a bearing on what the defendant knew or believed to be the factual situation in which he or she acted. Was what the defendant agreed to do with others dishonest by the ordinary standards of reasonable and honest people, not by the standards of the market in which the defendant operated, if different, not by the standards of the defendant's employers or colleagues, if different, not by the standards of bankers or brokers in that market, if different, even if many or even all regarded it as being acceptable, nor by the standards of various market regulators, but by the standards of reasonable, honest members of society. Why give that direction at all? I pose that because I suggest there's a bit of a paradox here. Bankers, brokers, compliance officers of regulatory authorities, they're not a class apart from members of society. As in one case called Robertson, decided way before Ivy, the Court of Appeal accepted that such persons were part of the ordinary community, if you like. And indeed, there might be bankers, compliance officers, sitting on the very jury where the direction, unless they've been excused, on the very jury where these directions have been given. And if the standards of the various market regulators do not constitute the correct standards to be applied, well, does that mean that, for example, a person should not be cross-examined on the basis of regulatory requirements? The fourth reason given was the second limb had led to an unprincipled divergence between the test for dishonesty in criminal proceedings and the test of the same concept when it arises in the context of a civil action. Now, to my mind, I suggest that that is probably one of the weakest reasons the Supreme Court gave. There are many cases where criminal law and civil law quite properly diverge. Burden standard of proof. Standard of proof. There are good reasons why the standard differs between the criminal jurisdiction and civil law. Fifth reason. The second limb represented a significant departure from the Pre-Theft Act 1968 law, when there was no indication that such a change had been intended. That's the reason, what I mentioned at the beginning, that the word dishonesty only entered the legal lexicon in 1968 with the Theft Act. There is nothing to compare. Finally, the second limb was not compelled by authority. Well, it may not have been compelled by authority, but nobody could say, surely, that Gauche had been decided per incuria. The cases have been reviewed very carefully and in great detail, and the Court of Appeal clearly weighed up a number of competing considerations. I'm coming towards the end, you'll be relieved to hear, but finally this. There have been suggestions that the notion of dishonesty might be challenged as lacking legal certainty. Much has been written about it. David Ormerod, Carl Laird, for example, have articulated this in some detail in the 15th edition of criminal law and in the Supreme Court yearbook, and both need to be taken very seriously because the arguments that they present are very powerful. However, that powerful may be in theory, but I suggest will not carry much clout with any court in the United Kingdom for this reason. typical practitioner response. If the court stick to the view that everybody knows what dishonesty is, it's like the elephant. You can see it, you recognise it when you see it. Well, if there's that degree of certainty, then where is the uncertainty? So, finally there is, I suggest, a considerable force in the remarks of Professor Don Stewart, not an English academic, but a Canadian one, who wrote in the 7th edition of his treatise on Canadian criminal law that it would be preferable to, and I quote, avoid the quagmire of dishonesty and simply rely on the more manageable concepts of intent and claim of right, where the focus is on subjective awareness, irrespective of motivation. Thank you very much indeed.
Well, Rudi, I think we're all very grateful for a tour through what is, as I discovered in preparing this response to your paper, a bit of a quagmire. I'd like to start by saying that I agree fully with Rudi that there were very good reasons for the former distinction between the civil and the criminal tests. It's obviously the case that cases centering on whether the defendant had a dishonest state of mind will involve understanding the context and circumstances in which the defendant was operating. So there is one thing that I like about Ivy, which is the first part of the test, which puts the facts that they perceived at centre stage. So it can be facts, true facts that they believed, or maybe a belief in facts that aren't in fact true. The reasonableness of those beliefs are not relevant to the first part of the Ivy test. But I do think that the loss of possibility of arguing that the defendant didn't consider their actions dishonest, and nor would anyone else, to be a significant and unjustifiable reduction in the scope of matters that a jury can take into account. We all know that sentencing for crimes such as conspiracy to defraud can be frighteningly long, and should society really be imposing this kind of punishment on people who at the relevant time were oblivious to any disapproval that their conduct might find. And I also question whether, if it's acceptable for a defendant to be judged on beliefs that they genuinely hold, however unreasonable that those beliefs may be, about the facts, why is it not also possible to take into account a genuine lack of appreciation of what ordinary decent people might consider to be dishonest? And it's in the cases in which I've dealt with as a practitioner, that question is hardly ever a straightforward one to answer. In the commercial world, there may be all sorts of factors operating on a person's mind, but also we have to think about people with mental disorders and those who may have been under particular strain and pressure at the relevant time. And those people are the most vulnerable and deserving of the protection of criminal defences. So why would we treat them differently to a person, for example, who might be accused of offence where recklessness is to be proved, where a subjective test is still at play? So far as the financial crisis is concerned, and perhaps this move has sort of followed on from that, I think if we took a step back, we might all agree that that was caused as much by recklessness as it was by dishonesty. And if Ivy was an attempt to try and capture those operating at the highest levels in organisations who may be able to influence how business is conducted, I suspect that the lack of prosecutions for those categories of people is more to do with a lack of evidence than a weakness in the former Gosh test of dishonesty. So I also wondered whether the case of Ray Chaudhuri, and I apologise if I'm not pronouncing that correctly, which was a case that was decided after Ivy, may to some extent be coming to the rescue of the subjective test. That was a case in which the Medical Practitioners Tribunal had found that the doctor who was an A&E doctor, had made a false statement in a phone call to his superior about filling in a form relating to the examination of a patient. But the MPT found that he hadn't been acting dishonestly when he made that statement. The GMC appealed, and Mr. Justice Sweeney, applying the Ivy test, took the view that the doctor had acted dishonestly in making that statement. And then there was a further appeal to the Court of Appeal, and there was then a ruling about dishonesty, and Lord Justice Sales emphasised that, in his view, the approach taken by Mr. Justice Sweeney was too cut and dried, and that in analysing the position as he did by reference to parts of the MPT's findings, whereas it was a case which the MPT plainly regarded as finely balanced, involving circumstances which required subtle but important, morally significant distinctions to be drawn. And so he put emphasis on moral distinctions, and he also went on to say that the MPT was well placed to make an evaluative judgment regarding the nuances of the interactions between the doctor and also the various witnesses, and most tellingly that the MPT was in the best position to understand the precise context and pressures under which the doctor was acting in that case. And then he also came back to add that the MPT clearly took anxious care and sought to weigh and evaluate the moral significance of the appellant's conduct in the context of that case. And so what, as a defence practitioner, I would hope to take away from that, if you're able to bring in the precise context, circumstances and pressures under which the defendant may have been acting, that it broadens out the perceptions of the accused beyond the mere facts that Ivy stated could be taken into account. And the other thing I did because I had a preview of Rudi's paper, was to take a look at the case of Hayes, which is the case of the LIBOR trader who's convicted for manipulating the LIBOR rate. I was interested in it because of the specimen direction that was in the compendium, and I went and had a look at what facts might have been admitted in connection with the first part of the Ivy test, that is the facts as the defendant perceived them to be. And there was a whole list of factors that were spelt out in that case, factors which in Hayes had been taken as part of the subjective test. And they were as follows. First of all, the jury was allowed to take into account the ethos of the banking system at the time. They were able to take into account the prevalence of commercial LIBOR requests from traders. They were able to take into account the use of interdealer brokers and to discuss potential LIBOR submissions. They could take into account the attitude of the British Bankers Association that operated LIBOR. That position being that the BBA knew about the association between LIBOR submissions and panel banks' commercial positions, and that the benchmark wasn't accurate. They were also allowed to take into account the attitude of the Bank of England and the Financial Services Authority, in that they had refused to step in or regulate LIBOR until 2008, despite knowing that the benchmark suffered from a flawed governance process and also that the LIBOR rate was not accurate. Now, I think many would agree that all of those points would be very germane when you've got a single actor in the context of something that was widespread conduct. And it was helpful for Mr. Hayes, he didn't prevail in the end, but it was helpful that he was able to pray-nade all of those items for his defence. But how would those be transported into Ivy? Because for Ivy, we have to look at what the factors as the defendant knew or believed them to be. And it may be that whilst the defendant may have been aware of some of those things, they may very well not have been aware, for example, of the lack of activity by the British Bankers Association or the Bank of England. And so one wouldn't be able to get them into the first part of the test, and one certainly wouldn't be able to get them into the second part, because we're told that the behaviour has to be judged objectively, and we're told that those items are not relevant to that test. So I also wanted to come back to the point that Rudi made about the exclusion of vast swathes of members of the public from the notional group of the ordinary decent person, as we're supposed to now apply the test. It would cover not only the people that Rudi mentioned, the superiors, the colleagues, the bankers, the Bank of England, but the regulators, but also people like the Financial Conduct Authority, whose very role it is to regulate what conduct is appropriate in a financial sphere. And so it is an absurd state of affairs, and it's the paradox that Rudi referred to is very much a live one. I did also wonder whether the Ray Chuduri case, which I referred to earlier, may be the beginnings not only of a filing down of the rough surfaces of Ivy, but perhaps a gradual retreat to a more subjective test. And I think there is an interesting comparison to be made with what happened to recklessness following the decisions of the House of Lords in Caldwell and Lawrence, where an objective recklessness test was replaced over a subjective test. And I had a quick look in Archbold before I came and found, according to Archbold, that that had been the subject of quite intense criticism, and that the Court of Appeal had become increasingly resourceful in limiting the effect of Caldwell and Cunningham. And then there was a House of Lords decision in RVG which reapplied the subjective recklessness test for all crimes. So it's possible that we may see a creep. But whether or not we'll see that, whether the Law Commission step in and there's a root of branch review, as Rudi suggests there should be, the problem that practitioners face is how can they best put forward cases for defendants who are contesting the absence of dishonesty. Well, first we can focus on assembling and presenting evidence of the facts that the defendant believed to exist, and this evidence can be used to enable jurors to stand in the shoes of the defendant at the relevant time and to understand the context in which they are to judge whether or not an ordinary, decent person might view the conduct as dishonest or not. And I feel, as a practitioner, I think we spend quite a lot of time trying to help juries understand how it would be to be in the defendant's shoes. And the more they can understand about the facts as the defendants perceive them, the more likely it is they will understand why a defendant acted as they did, and then they may be able to make the subtle but morally important, morally significant distinctions of the kind that were described in Ration Jury. We can also consider whether we could use expert evidence to, for example, if the defendant gives evidence about their perception of the facts and that their perception would appear to be implausible, then there's a possibility of introducing expert evidence about their mental processes there, but we would need to balance that against the possibility that the very same evidence could be used to drive a wedge between them and notions of the moral compass of ordinary, decent people. And finally, I think there is a role for prosecutors to play here, in that they may wish to consider whether it's in the public interest now to prosecute defendants in cases where there is a real danger of a conviction for a person whose thought processes may have been different to those of ordinary, decent people, due perhaps to temporary or permanent mental impairment. I accept that I'm probably coming at this from the point of view of someone who's defending, and I'd be very interested to hear as well what prosecutors think of the situation. But those are my thoughts anyway.